Hey y'all, Bonnie Roden here, your favorite family law attorney. I'm with Roden Law Group in Brevard County, Florida. So we're in video 9 today. So this one and one more, and then we'll be done with equitable distribution. Today we're going to cover 5 areas, sometimes misunderstood areas for Florida divorce cases. We're going to talk about enforcing court-ordered property division. We're going to talk about what to do when experts disagree on an asset value, like 2 appraisers that appraise your house differently, how inheritances are treated, and the impact of second marriages or third or fourth or fifth, and how equitable distribution works when there's no real estate, no house, no extra properties. So these topics come up more often than you think. Knowing the basics of the law can help you prepare better and also can help you help your attorney. So let's talk about enforcing property division. Sorry, I'm in my dining room and I have birds flying all around outside, so it's distracting my vision. So a final judgment of dissolution, the final judgment is the final order, that includes a property settlement is legally binding. If your spouse or your former spouse at that time refuses to comply with the order, such as, failing to transfer title to a car or sell the house, or sign off on a quadra, which we talked about in video 8, which is to divide retirement assets, you can seek enforcement under the rules, the Florida Family Rules. Rule 1.570 is one that might apply. And in really severe cases of failure to comply, the court can impose sanctions under the powers of contempt. So there's a case, it's out of the 4th district, which Brevard County is in the 5th. It's Miller v. Miller. It's a pretty basic one as far as the name is concerned, but it is a 1997 case. And in that case, the court confirmed that specific performance is a valid remedy for enforcing property transfers that are ordered by the court. So specific performance is the court forcing a person to take an act. So that means that in your final judgment, you have to have acts. And unfortunately, there is case law that says that the act of writing a check is not actually an act that can be forced through specific performance. However, agreeing and meeting with a realtor, signing a listing agreement to hire a realtor and list a house, price reductions every 14 days as recommended by a realtor, closing instructions included in your final judgment. These are all things that can be enforced by specific performance. So it's really, really important that you document everything up through the final judgment, and then you keep documenting everything until all of the actions to equitably distribute your property have been completed. So let's talk a little bit about disputes between experts. So I hire an appraiser and you hire an appraiser. Mine says 500, yours says 400. What do? These disputes come up all the time when you each have an expert. It happens a lot with business valuations. It happens also sometimes with pensions and real estate, of course, the house. Courts will evaluate the credibility of the expert, the person giving the testimony, the method that they use to come to the value, and whether or not they're related at all to the case. So is it somebody's brother-in-law that did the appraisal, or was it a truly third party, not associated with the divorce expert? The judge can choose to adopt one expert's opinion in its totality, or can blend together the opinions of both experts, or if there's more than one, and 2 and 3, you can blend together all of them in order to reach what the court considers an equitable or fair result. So there is a case that lawyers deal with all the time. It's Rosen v. Rosen. It's, again, a 4th district case from 97. And in this case, the court emphasized the need for objective, well-documented valuations. So don't just go out and hire the first person you find online that says, I'm an appraiser. You want to make sure that you get in touch with an appraiser that has the highest qualifications, and make sure that when, especially with real estate valuations, that the appraiser complies with their own license requirements. Very often, we can have the testimony of an expert appraiser excluded because we send a request to produce the reports and all the documentation prior to trial, and the appraiser cannot produce that. And those items are what's required by their license. So make sure that you don't just go out and hire any, Joe Blow to do the appraisal or to do your business valuation. All right, so what about inheritances? So inheritances, whether it's during the divorce or prior to the divorce or even prior to the marriage, an inheritance, by its very nature, should be non-marital. However, and of course that's under statute 61-075 in paragraph 6, subsection B, even if it's received during the marriage. So by its nature, an inheritance is non-marital. However, there's a catch. If inherited funds are commingled or used to buy marital assets, it is very possible that they're going to lose their non-marital status. So here's an example. I inherit $250,000 when I'm 21, and I buy myself a house, and I live in that house until I'm 30, and I meet Mr. Wonderful. We get married, and he moves into my house, which is maybe non-marital. Still, we sell it. We buy a bigger house. Now we're both paying on the bigger house. My initial $250,000 that went in to buy that house initially is likely commingled out of non-marital status. So you have to be very, very careful how you go about things. A prenuptial agreement can solve that, because that house that I bought with my $250,000 inheritance, if I have a prenup when I get married that says my income and his income are non-marital, then when I make the mortgage payment every month on that house, that does not make the house a marital asset. It keeps it separate. So it's important to be prepared, and you'll always hear me say prenups are a good thing. So regarding inheritances, there is a case. It's a 1992 case. It's the Amato case, where the court ruled that inheritance deposited into a joint account becomes marital because it was commingled. If you want to, under this case, if you want to preserve the non-marital status of the money, deposit that inheritance in a separate account for all purposes. So completely new. Take your inheritance check, go to the bank, and give them that check. Don't open an account with $20 from your joint account or from some other single account that has marital funds in it or income in it. You want to go to the bank with your check and give that check to the bank. Let them open it with that deposit and keep it entirely separate. Don't transfer savings into it. Don't say, oh, I'm going to save over here. Don't put your paycheck in it. Don't put birthday money from your family into it. Keep that money completely separate. If you want to transfer it out into an investment account or a stock account, or buy crypto or whatever other things you want to do, buy a racehorse, make sure that it's all done separately, all of it. And if you buy the racehorse, don't pay for hay for the racehorse from your income unless you have a prenup that says your income is non-marital, because then the horse is being maintained with marital hay. All right, let's talk a little bit about equitable distribution in subsequent marriages. So second marriages, third marriages, etc. They often involve families that are blended. They have premarital assets, they have retirement plans. Prenups can help, but if you go it without a prenup, the courts are going to rely on the same statutes and the factors as any other case. So first marriage, 10th marriage, doesn't matter. The same commingling concepts apply. So there is a case that lawyers use often. It's a 2007 case out of the 3rd District. That's the Castro case. And in that case, the court emphasized the tracing of premarital funds. So when one spouse contributes significantly to marital expenses, if a spouse puts separate money into a jointly titled home or account, that party that put in that money has to prove how much of that they can trace to recover it. So that $250,000, if I put that $250,000 into a joint house that we purchase when we're married, and I can show, if divorce happens, I can show a link from my inheritance to my house and from my house sale premarital that never had any marital money put into it, not mortgage payments or anything, I can trace that from there into the new house, then that $250,000 might not be categorized as commingled, and you might be able to trace it enough to protect it and have it excluded from distribution. Okay, let's talk about this last one is about property division when there's no real property. So real property is real estate. I don't know why we call it real property, but real property, you can think to remember real estate. Real property, real estate. Houses, land, etc. But not all divorces have houses, condos, land, or other property. In those types of cases, the focus is going to shift to retirement accounts, vehicles, personal property. Personal property is like all the stuff you see behind me. The lamp, that's a fixture, that's part of the house. The tablecloth, that could be personal property. The glasses and the dishes and the things hanging on the wall, that's personal property. So Florida will still apply equitable distribution, the principles of equitable distribution, even if your total assets are only worth $2,000. There is a case, there's always a case. This is a case from back when I was in high school in 1987. It's from the 3rd District Court of Appeals, and the name is Grits with a Z. Not Southern grits or cheese grits, but grits with a Z. The court in that case held that each party is still entitled to a fair portion of what does exist. So if there's a modest marital estate, it doesn't relieve either spouse of disclosures, the duty to disclose, or it also doesn't entitle one to more simply by default. You still want to keep track of accounts regardless of whether there's $50, $500, $5,000, whatever's there, you need to keep track of it. You need to know what you owe, what you own, and what the values are for each one. So in closing on these topics, these issues, whether we're enforcing court orders, whether we're dealing with inheritances, whether we're dividing non-traditional assets, our pets, this requires a sharp understanding of Florida law. So make sure that you're working with an attorney that knows what happens to all the different types of assets and how they're valued and how it's treated, and what do you as the client or the party need to bring to the table to create a basis of evidence to support your testimony. So it's important that the client understands that. It doesn't do any good for a lawyer to say, go get me your bank statement for March 4th. You need to understand why, so that you can, come back to your counsel, who is your partner in this activity of divorce, and feed them information that will be helpful during your case. If you need help, we can help you. We function in East Central Florida, mostly in Brevard County. You can contact us through the website. You can leave a comment. Make sure to like or follow if you want to get updates when we post new content. See you for number 10.